Yes, Hindu law, our Hindu law is depend upon Vedic guidelines, and India follows doctrine of res nullius, not like other countries, Western countries, eminent domain. So far properties are concerned. Res nullius means those who found the property first are owners of the property. Therefore, India, all over India, including the Pakistan, Afghanistan, everywhere, the property was owned by them by hereditary, and that according to Hindu guidelines, the property was managed by male Hindus, and two upstairs, down, two down. Uh, Therefore, the middle of the person was called as Kartha of the family, and so many laws were there. That was the reason the Hindu law, so far, whenever issues brought before the court, it was the Hindu Pandit who knows Vedas. Chaturvedi means one who knows all four Vedas. Trivedi means one who knows only three Vedas. Dvedi means one who knows only two Vedas. Ekadi, it means one who knows only. So, Rik, Yajur, Sama, Atharvana Vedas are the four Vedas. And thereafter, so many things are there for Hindus. These Vedas was initially heard and spoken, Shruti and Smritis, and being followed by hereditary, by Gurukula. Thereafter, they want some simplifying Upanishads. Then thereafter, Prabandhagas, what not, so many things. Then Smriti was there, Manusmriti. Shruti is something different from Smriti is Manusmriti. Then they have their own interpretations that divided the sect of Hindu law as one Dayabhaga and the other major sect, Mitakshara, was being followed in all over, and there are several subsects. They have their own laws. Then what happened? The main thing was now when Dr. Ambedkar introduced in 1956 Hindu Succession Act, he want to abolish the system of compulsory property, means maintenance of ancestral property by one head. But that was prevented, and still that holds good. And women were treated as one of the members, but they were not allowed to claim partition or property right. But however, they are dignifiedly maintained by the Kartha of the family. But later on, Widows Act 1937 was introduced. Then 1956 Succession Act, there was absolute rights were given to women. Then it was going on, and still till 1988, somewhere when Andhra Pradesh government introduced the amendment empowering the woman also to claim partitions. The same was followed by Tamil Nadu, and thereafter 2005 Hindu Succession Act was suitably amended, and there is nothing survives because all women are equally entitled as a proportionals, and they have got every right to have claim of partition. Here, this is only for narrations. I want to refer this judgment, which may help you for academic interest and at least for have a knowledge. Here, AR 2022 Supreme Court 65, Veera Reddy, Dasaratharami Reddy versus, his name is B.D. Reddy, versus Manjunath. This Reddy was father, Manjunath was the son. The only concept was, he was Kartha of the family. He executed a sale deed, agreement to sell, and suit for specific performance was filed, and the son has said that he was not party to the agreement. Therefore, Partha have no right to sell the property, but The lower court accepted it, but High Court has set aside it and granted relief for son, setting aside the agreement for sale. But the Supreme Court has, after discussing so many articles of Modi, Mullah Indula, you go through all those things and said that the Kartha has got every right to uh, alienate the property for the purpose of interest of maintenance of the compulsory property and for other purposes, except the legal necessity, other things, except he was prohibited for other illegal purposes. So many cases are there. Discussed, you kindly go through the judgment, may be helpful only for the academic, but it's a landmark judgment. Somewhat because nowadays these earlier only Hindu cases are filled up before the Supreme Court. Multi number of cases were dragged to Supreme Court for years together, and women's rights were deprived of. So those days have now gone. After a long interval, the case law about Hindu compulsory property was delivered, connected with specific relief act section 20. So it is very helpful for academic student, postgraduates, research scholars, and those who have habit of writing articles, theses, dissertations, etc. So this judgment should be kept on your record for the curiosity to last student. Best wishes.